todos.
Good afternoon, all of you. It's a pleasure being here. Last section, last day of the 8th International Forum on Tax Law, International Tax Law, the 8th Brazilian Forum on the subject. And now we will have the Minister Alexandre de Moraes with us. There's no need of any presentation, but I set a point. One thing I want to say, besides a professor of USP's Law School, is also a person that is in the Supreme Court a lot before being a minister, due to the works, the publishing, etc. So he is a minister, but he was part of the scenario there in the high courts. It's important to mention that. And in fact, of course, the background, the analysis of this constitutional matter, the knowledge he has about the subject. We will deal with international treaty subject. That's the last section of the day. And here we have IBDT, that is with us, Professor Ricardo Mariz de Oliveira, which is the president of the Institute now. And we thank Professor Luiz Eduardo Schwery, an articulator of all the meetings, and also the presence of people from the Department of Financial, Economic, and Tax departments of USP Law University, that IBDT is with them since the beginning, when Rui Barbosa Nogueira was there. So it's always an enormous pleasure being with all of you, and I thank for the invitation, and I immediately pass the floor to Minister and Professor Alexandre de Moraes for his talk. I thank for your time on behalf of IBDT and USP to be with us in this moment. Good afternoon. It's still boa tarde. Good afternoon. And I greet my friend, Professor Fernando Scaff, my colleague of the USP University, and Professor Ricardo Mariz de Oliveira, that is here. Congratulations, everyone, for the 8th Forum, Tax Law International Forum, and I greet the participants and the members of the Department of Economic, Tax, and Financing Group in Largo de São Francisco. That's our law school. Professor Schwery, another friend, a big friend, and he has invited me a long time ago, and I accepted. The issue or the subject we are going to deal with, international treaties, when it refers to tax matters, it demands an analysis, firstly, about the treaties themselves in terms of a federal constitution. It's impressive because, by coincidence, this has been discussed in a recent judgment in the Supreme Court, not definitive, in RE 460,350, analyzing something very important concerning conflicts, eventual conflict between treaty and Brazilian law. Volvo do Brasil, and it was possible to solve without definition, and it will be defined. Article 98 of CTM that we will refer to now. I would like to start quickly, briefly over something important, saying that, in my opinion, the Constitutional Amendment 45, when brought alterations In paragraph 3, Article 5th of the Constitution, in fact, it, in my point of view, defined for all eventual conflicts in international treaties concerning tax with ordinary laws. Why? Because it significantly changed the incorporation of treaties subject, summarizing, I know you follow the issue, Brazil defined with the Constitution of 88, adopting this theory of it's a dual moderate position, despite some defend the possibility of incorporating an international treaty in Brazil if there is not the participation of two powers, executive, two branches, executive as head of the state, president of the republic, signs the treaties, and the national senator, Congress, has to approve it via legislative decree, another branch, and after the approval of the National Congress, traditionally via legislative decree, then it's issued by the president, and this decree will execute the international treaty, incorporating it to our legal order or system. Uh, uh, so, as an ordinary rule. So there was a big discussion, mainly concerning 88's constitution, defenders from both sides, a big discussion. If treaties referring to human rights would be incorporated immediately, and in second instance, not immediately, but there would be the possibility of incorporating it, I would say, constitutionally or supra-legal. And this discussion was extended till the issuing of the 45 constitutional amendment, and there's a new possibility, extremely interesting, the possibility of having treaties, international treaties concerning human rights being incorporated in the legal system in Brazil, with voting of three-fifths of the chamber and three-fifths of the National Congress. So paragraph third accepts the possibility of incorporation as the constitutional amendment, as a constitutional amendment. So at the same time, this alters the idea of dualism that Brazil was adopting, because as long as you do the incorporation with three-fifths of the chamber, three-fifths of the Congress in two runs, so there's no need of having a presidential decree to set this incorporation, just a promulgation from the part of the chamber and Senate. And it was done in one single case of incorporation of treaties, international treaties, representing a constitutional amendment, or just like one people that are disabled. So at that time they said people that had a deficiency. Today we say disabled people. So it was accepted as a constitutional amendment. And this is a very important convention and too much details. I say that because at that time of the approval of the 45 Amendment, it was considered to have a problem, a big discussion that one day will get to the high courts, because conventions that are too much, with too many details, let us say, the size of the adaptations that have to be done, let us say, can you revoke it after the incorporation? And you're referring to human rights, special cause. So paragraph 4, item 4. So what's incorporated as a matter, is it patron cause or not? When we get to this cause, these points, we'll discuss it. Now, this amendment, in my opinion, it reinforced the fact that before the constitutional amendment, any international treaty incorporated per Article 49, paragraph 1, these treaties incorporated via the traditional procedure. President signed it, the Congress approved via majority. So it's a presidential decree. All this procedure was correct, traditional, according to the rule, and the incorporated treaty be an ordinary law. Because before this amendment, there was a decision of the High Court concerning the Convention of OLT, where the Supreme put aside because the convention was dealing with the matters of Article 7, item first, and it required complementary law. So there was no judgment of the merit of it because the President of the Republic revoked the decree of incorporation. So it was harmed. But with 45 amendment, the legislators doing the reform sent a message. Let's stop with this discussion and human rights treaties that are to be incorporated with constitutional force, the procedure is here. Okay, approve is the same like an amendment of the Constitution. For me, it does not mean that there is no possibility of incorporation of human rights treaties via the normal procedure. They wouldn't be with a status, constitutional status. It's supralegal, defined now by the Congress. I know that many people say that this possibility does not exist, but I see, pragmatically speaking, requiring that the Congress always approves these treaties with a qualified majority of 3/5 as a constitutional amendment, it may be an obstacle to the reception of the treaties by Brazil. So there is the political option in the National Congress. For the others, there isn't any. The others have to refer to the procedure that was established. To the others, it comprehends exceptions apart, eventually let us say, tax guarantee, so right of property, that is an individual right. But as a rule, the other treaties incorporated by the dual theory with the force of an ordinary law, the other treaties comprehend the tax issue. Therefore, we have the question that is placed and discussed. There's no difference in terms of incorporation of the treaties related to tax rights and the others. This group is aside, incorporated with base according to Article 84 and 49. The other side, we have the possibility of the human rights treaties having a status of a constitutional amendment. If Amendment 45 has done the split, how do we maintain that the Article 98 of the tax code, national tax code, including the treaties, international conventions, obviously, as part of the tax legislation, Article 96. How should we sustain that there is supremacy, generically speaking, in terms of the ordinary legislation? If 45 Amendment had the possibility to alter it, dealt with the subject and made just a simple distinction, treaty related to human rights. I insist on it. Professors well known of tax law do this distinction. These treaties about tax also consider individual rights, as the Supreme Court has acknowledged. So how can we, how should we deal with this issue? And the High Court, the Federal Court, has gone this way and changed the idea, but discussed the incorporation of tax subject in this idea, the dual uh, theory. So with contours that are very specific, according to the case law and according to the jurisprudence of the Supreme High Court. So in the first Brazilian constitution, when it was Republic one, when it was in force, that's the second one, but the first Republican. So the federal court was established, the Constitution of 91, the Supreme Court, at that time, Federal Supreme Court, acknowledged that international treaties, not only specifically concerning tax, but acknowledged that international treaties would have some priority concerning internal legislation, and it was in the extradition number 7. The reporter was Minister Canuto Saraiva in 1940. So it simply annulled the previous judgment because Brazilian extradition law was set apart. It was 1911's law, and to use the extradition treaty between Brazil and the German Empire at that time. And so it was the time of Brazil that, as an empire. So, so concerning taxation, the when the Constitution of 37 was in force, in the first moment, the Federal High Court understood that norms or rules, internal, domestic, infra-constitutional, will be below the international ones. It's an important appeal, civil appeal, reported by the Minister Philadelphia Azevedo. The court at that time ruled and put aside the additional tax of 10% by decree to privilege a treaty between Brazil and Uruguay. At that moment, it was understood that it would be
Prevalent the right, international right, I mean, to be truthful, here the reporter, Ladelfa Azevedo, had a trend of privileging international standards, and he had an appeal for international law. So after he was appointed Aya International Court judge, but it followed the understanding of the reporter. This remained under the effectiveness of the 46th Constitution, also by the STF, Supreme Court. There was a possibility during an civil appeal to judge commercial trade treaty United States America. Uh, it was named trade uh, between Brazil and USA, and the STF in this ruling once again focusing on the controversy between treaties prevalence with foreign states and internal rules or norms, thought that it was right to uphold the issue of prevalence of treaties regarding tax rights of the domestic rules. And up to then, this appeal and development of this ruling by the STF, Constitution 91, 34, 37, and 46, until the ruling of this last appeal, Brazil and United States treaty by Lafayette de Andrade, minister, was in 51. Until then, there was no rule by the National Tax Code that was published in October 25 of 66. And following this understanding that the court came step by step creating the National Tax Code in 66, brought Article 98 and the wording always difficult, and this generates many ways of understanding, saying that international conventions and treaties revoke or change domestic tax legislation, and if they're not complied with, it will overlap. And this wording that in theory intent, if we see the debates at the time by the National Congress and doctrine debates, this wording that intent to consolidate the understanding of some decisions by the STF and the conflict of domestic rules and international law duly incorporated ended by creating more confusion than solution. And why this? By confirming first the international and international convention revoke domestic law rules, then we will uphold the parity of status between both. Later, act revokes the previous one. If we don't pay attention that it overlaps, this final ended by giving an absolute character, even though it would not have the speciality principle, ended by giving an absolute character that by many was used as a confirmation of the national tax code at that time had the status of ordinary law as complementary law, but it ended by having an idea that the legislation, the infra-constitutional legislation, either ordinary or now complementary, that this infra-constitutional legislation would have the authority to set forth that the international treaty is more than the law in domestic law, even if this treaty was duly incorporated. Always the indagation here, would it be matter for infra-constitutional legislation if the constitution does not set forth the hierarchy? Could it either at that time ordinary law or seen as complementary law? Could it be infra-constitutional setting forth this differentiation? Well, and the 16 code came the constitution at 67, then the wording provided by amendment number 1, the STF Supreme Court ended by at first saying that international treaties would be immediately enforced, including that modifies domestic legislation. And there's a second part of Article 98 of CT and the tax code. More confusion regarding the first part because at first it ended by a monist theory being the adhesion, the 71 words in huge confusion regarding it by Ministro Osvaldo Trigueira. Then the plenary approved a súmula regarding the merchandise. Súmula 575 regarding imported from GATT signatory country import allowed. This was something isolated because based on, as of 77, the Supreme Court regarding the this issue, the Supreme Court not only upheld dualist theory 88004 reporter Peixoto, not only upheld the dualist theory, but the Supreme ended by confirming the parity between international treaties and domestic norms that are infra-constitutional. So then the Supreme, based on this RE, it's dealing with the second part of Article 98, i.e., the enforcement of international rules regarding domestic rules. So it no longer accepted the end of Article 98 that set forth it will be complied by those that come later. So the interpretation that would be something automatic, no matter what comes later, the treaty prevails over the ordinary law. This was um, pushed aside under reporter in a very positive way, placed that there were no article in the Constitution at the time that declared it irrevocable, a law, positive law of Brazil, because its source was based on a treaty, because this is what it was all about. This way of understanding Article 98 made it irrevocable. This, by domestic legislation, this normative assimilated by Brazil's law, the international treaty regarding tax matter, duly incorporated legislative decree, presidential decree could only leave the legal order if the president by decree revoke the previous decree and should denounce internationally adopting the measures, and some internationalists they advocate this up to date. And the National Congress, which is the forum of democracy and chosen to regulate all issues, domestic issues, in fact, that are infra-constitutional and exceptionally as the authority arising from the reform and by the constitution per se, and the Congress would be hands tight. So, treaties of tax matter that were incorporated by previous governments could be upheld even against the positioning of the National Congress, as long the president did not revoke the presidential decree that has incorporated. And then what Cunha Peixoto, the minister, said there was no article that guaranteed the irrevocable capability of it. So the issue here is of the status is the same, and we would enforce the idea of speciality. Posterior law revokes the anterior law, so not all ministers ingress in detail in this issue. Many, inclusive the one that was from the STF of the course of São Paulo, Thompson Flores, Rodrigues, Leitão de Abreu, Cordeiro Guerra, they expressly follow the ponderations of the reporter regarding Article 98. But they said it will only be enforced up to certain treaties contracts. And here we have the debate that not all accept. Some criticize the difference between normative treaties, treaties contracts, and in fact, it could even be construed as specific rules regarding the general. And I make this differentiation, and also I don't find it necessary to make the differentiation of treaties because those that are deemed as contracts, they are so specific for the enforcement of speciality principle, hardly would not be applied. So then normative treaties, in fact, these would be applied the posterior law. We would, and this was the line followed before the understanding that was approved, but earmarked to the traditional criteria of apparent conflict of rules and norms applied to all conflicts, either tax law or the other branches of law. So, posterior revokes the anterior, and so, and the Supreme was upheld holding this positioning based on this case. Later, other rulings, not in tax matter but criminal matter, HC 5857 upheld this position. And even with this positioning, the Supreme Court did not never state inconstitutionality of Article 98 of the tax code from 88 Constitution. The right, and important to mention, to say there was, we didn't have, let's say it's no, not the merit, because each moment of history has its own peculiarities and complexity, but we did not have at the in the pre-88 constitution, we don't have a constitutional jurisdiction, the true one, the one, the terms we know today. We had diffuse control traditional in Brazil since 1891 with adaptations of 34, because we imported diffuse control from USA. It's imported by Roman German law, the common law with precedents. So if it was stated in constitutional, was for that case. If the district court judge did not want to enforce, he didn't have to. Diffuse control came sort of lame. In 34, we tried to organize it better, either with the special clause of reserve or plenary as upheld by the Constitution, or the possibility of federal Senate to uphold the one that it's deemed unconstitutional. And so just in 65, by Amendment 16, it was concentrated, but to control the legislative, then to create a constitutional jurisdiction and abiding by the jurisdiction of constitutional rules. I say this to have a better control of legislative. We are talking about 65. It's 1 year after the rule of law that was toppled by the military regime, and the National Congress kept functioning. We were in the 60s, and it was not popular to close down the National Congress. So what was done, and by guidance of a former Professor Silva from the University of São Paulo, if Republic Caution controlled the possibility of one person asking the STF the statement of inconstitutionality. Who was this person? the prosecutor of the Republic, but at the time was chosen freely by the president and more. It could be laid off ad multum any time. Of course, this does not mean that we don't have big figures in this job, but it means it was bullseye. So if the Congress eventually approved something against the interests of the government at office, general prosecutor that was dealt as a minister, it was a job of the that the president chose. So up to 88, we have few cases that important that could create a true constitutional jurisdiction of Brazil. This since 88, it modified fully because Brazil is a country that granted legitimacy for the access of the STF regarding the concentrated control. By far, no country comes close to it. I joke, almost anyone can access the STF in Brazil. So, concentrated control, in addition to this, after the regulation of DPF, previous law, municipal laws, conduct by public authorities can reach the Supreme. So, because we don't have it, I did this. I told the history now because a we did not have a constitutional jurisdiction that is concentrated in Brazil. Article 98, where it weighs lots of doubts regarding its constitutionality, was not definitely removed by the courts. Cases were judged, and the understanding was that there was no hierarchy amongst.
So, international treaties with tax law and internal legislation that would be solved by the principle of the expertise. So it remained even having the Supreme Court, the Federal Supreme Court, in relation to the fact that has been reported in 1980 by Minister Moreira Alves, applied to a case, a specific case of Montevideo Treaty, Article 98 was used. But it's important to place that this was outside the normal procedure because normally it was not done this way. But in the same judgment, it set aside the living case, but it was isolated because it has been considered post factum another one that has been done and reported by another minister. Montevideo Treaty was considered as a contract, so it was possible because the principle of speciality said that we could use the Article 98. So that's always the issue of the Article 98 was not considered constitutional, but presently would say that this interpretation is according to the Constitution, saying that is according to the Constitution, because in the treaties, if it can be used due to the principle of expertise. So in today's language or saying, I would say that's the question. And after all that, the Constitution of 98, what's the thought of the Supreme Court? Not what they have ruled, but what they consider about the subject. The constitutionality of the Article 98, sorry, about non-constitutionality. It's been surpassed and it's been expanded because the rules of international characteristics just were considered in the Brazilian legal system with the same threshold of the ordinary ruling. So, due to speciality, there is a beautiful vote of Minister Celso de Mello minister, end of the 90s, around 97, according to Law 1480, doing this analysis based on the new Constitution of 98. Minister Moreira Alves previously had done that after the Constitution of 88. He started questioning the constitutionality of the Article 98 of the Supreme Court. Yeah. So ADI 1600, Minister Moreira Alves expressly, I separated a comment here. People asked, the collector representative used the 98, evidently it's non-constitutional and it's been revoked by the Constitution today. It should have been done before because it refers to hierarchy of treaty concerning the ordinary law. So the award that was presented, the agreement, sorry, that was presented after 84 by Ministers Moreira Alves says that it was used just because it was treaty. Now, the 88 Constitution in force already. Moreira Alves, minister, put that idea aside concerning his vote, saying that the Article 98 was not constitutional. It seems that, and I reaffirm that if there was any doubt concerning 88 Constitution after Amendment 45, any doubt, but I privately understand that with 88 Constitution, Article 98 couldn't be considered as a prevalence of the treaties in tax law, including considering posterior legislation, because then you tie up the Constitution differently. So you have to consider the dual aspect, moderate aspect, reinforcing that via the general treaties concerning the Amendment 45 that point out only the treaties related to human rights. In this sense, it seems that there is not any possibility of considering the prevalence of status or the non-possibility of revoking. And I add, very tranquil, that not only I always defended as a doctrine, but recently, as I said, in the RE 460-307 originated from Paraná. So I defend my positioning via vote, i.e., there is not hierarchy between treaties that discuss, first of all, tax treaty. I believe nobody discusses it. You may not agree, but you do not discuss. To be incorporated, you have to have a dualist moderate theory, and it's considered moderate because different from other countries where the president approves and assigns and approves a law, so it's executed. So concerning the tax treaties, there is the necessity to incorporate the moderate dualism. After this incorporation, it's an ordinary law. As such, posterior law changes the previous one, and the posteriori ones that eventually are tax matters, we have to analyze them under this criteria of expertise, speciality, or chronology. That was exactly the discussion dwelt in, in this RE 320 between Brazil and Switzerland to avoid double taxation on revenue or income in this case. So it's been solved without any need exactly of getting into 98 article. It's been analyzed, and I said we still do not have a positioning from the part of the High Courts concerning Article 98, but in my point of view, and other ministers as well, not all of them are part of the 98, but the 98 maintains its constitutionality if it's according to the Constitution, its interpretation. The same hierarchy that you have for the speciality and chronology principles. If question or normative treaty or agreement, sometimes it hides the idea of speciality. When you talk about an agreement or contract so specific among people that are parties, difficultly the law would be more specific. I consider that after Amendment 45, there's no way to treat it differently. If Article 98 was not considered, okay, I rephrase myself. We understand that it has been accepted by the Constitution 88, so let us say concerning 95, very difficultly. Now, Friday, 6 o'clock, I will give you some food for thought, only that, about another point that would deserve a discussion aside, and that it's very intriguing. The possibility, and there is this possibility, Dona Sara. So concerning my colleague, Minister Carmen Luz of the Supreme Court, understood that it's totally possible concerning international treaty, the getting together exemptions in relation to states and municipalities. So most of the doctrine, tax doctrine, when you execute a treaty, the president signs, the Congress approves, and there is incorporation by the president. So it's like a republic, not union, but republic, federation. So not union. So in this case, I tell you that I doubt concerning this issue because it's beautiful to say, I like it, to do this differentiation between republic and union. But when the Congress, the National Congress, approves an international treaty, who approves? The same representative, same Senate. So the same poll. If there is anything that is one of the biggest guarantees of federalism, is the characteristic of rigidity in our national tax system, imposing to each federative agency its competence in terms of tax. Obviously, I don't have to go farther and mention this because you understand about it much more than I do. Concerning administrative competence and legislative ones, where you have the remaining powers of the states. So tax case or issue is so serious concerning collection that Constitution establishes very precisely what remains to the municipality, to the state, and the union, even the residual, specifically in Articles 154, but it does not establish remaining powers to be legislated. So, in the competence we have to the competence to establish a tax and replacing the previous one. So, in that case, in principle, I place that because I think it's important to mention concerning international treaty, concerning tax rights and tax law. You cannot give a blank checkbook to the president or the Congress just to decide about exemptions, incentives related to states and municipalities. So it would be very dangerous to do that because it may harm activities, administrative activities of the municipalities and states. So it should be analyzed. The generic idea that when the President of the Republic and the Congress are representing the federation, not the content union. So we should check if the states and the municipalities are also gaining something with that. If it's referring to the whole, if there is a balance, exemption, and incentive. If you permit that Brazil adapts itself to international scenario, states and municipalities also will have benefits concerning that. Because otherwise, we centralize more and more the resources with the union, and more and more states and municipalities have less income. So the treaties, the union represents the federation and executes treaties that are benefit to them. And the collection is more and more centralized. So you diminish one of the fundamentals of autonomy of a federation, that is the income that concerns the municipalities and that concerns to the states. So we have to go more in detail about that because what we live is a federalism. The states and municipalities have to simply beg the union for money or in fact, there is no autonomy in the federation if there is no financial autonomy. If states and municipalities do not maintain and pay their employees themselves, imagine health problems, education. How can they do? So they are not autonomous politically speaking. That's an issue that's so important. I leave that food for thought, and I thank you again and a lot for the invitation done by my friends, Professor Schwere, Professor Scaff, and I thank for your attention. Thank you very much. Thank you, Minister. It is a class, a magna class. To close our meeting, this forum. This theme is so interesting with several aspects, the analysis well done of several aspects of this jurisprudence before this constitution that's spread and then enforced, referring to ministers that are part of our history, including concerning the intermittent representation that is part of the previous constitution. That was very interesting because the profile of that was a way of tying the Congress. It was very interesting. The analysis is very interesting. In fact, I say that our Supreme Court, the federal one, is more powerful in the whole world. It's the most powerful because it gets the diffuse control of the North American system when ministers. Uh, so until 75, we have people there, and it also has the UE way where the people have mandates. So you have controls that gather European and American profiles in a court that is very well in the scenario. Huh? Scaff, if you permit, I'd like to comment that we get the diffuse control of the High Court and the concentrated control of the constitutional the courts in Europe, preventive control done by France because their parliament was built this way. And let's bear in mind that this conquest crossed several generations before the Supreme Court, when in fact it did not exist. So it concentrates the defense of individual liberty because any habeas corpus can go to Supreme Court if there is no previous concession. So it's a court that is overcharged, and what I mention is that as it is the biggest legitimacy to access, everything goes to federal court. So we are constantly criticized. And I do that, and I used to tell that before becoming a minister. I said that at class and doing talks. And so the Supreme Court is criticized because they simply put their nose in everything. They say, but it was not the Supreme Court that got it. People gave to them this power because people go to them. So biggest politics issues, the parties take that to the Supreme Court and they have to decide because there is not in Brazil the possibility of no decision. The Supreme Court has to decide. So between errors and rights, I think that as an institution, the High Court, since the beginning of the Republic, they have more rights than wrongs. So, of course, there's no doubt about it. The freedom, the way you've placed it, that people have to reach the Supreme Court. It's so important to mention. Minister, I would have some questions from the audience. I myself would have around six. Of course, people, it's Friday. So, of course, with all the reservation imposed by COVID, but we think it's sexta-feira, it's Friday, it's time to go home. So I would like to repeat that intriguing issue concerning federalism. It's extremely important, and this will reach the Supreme via some debates of the PECs, the tax that are flourishing. So IBDT discussed that several times. It's worrying what we have ahead of us. The 98 issue has a margin of debate, but we won't do it now because our event is finished. So we have, in terms of expenses, we do not have a ceiling, but in terms of time, we have a ceiling, mainly on Friday afternoon. So on behalf of the institution, our Department of Economic, Financial, and Tax Departments, on behalf of IBDT, I also thank your presence and the presence of everybody here. I'll pass the floor to Minister final. Okay, so let us say we are not a tribune here. I won't say final reasons. I will say the closing of the event that will be done by the president of IBDT, Professor and Attorney at Law Ricardo Mariz. So I thank you all for the presence. Now, Minister Alexandre Moraes will conclude. I only have to the only thing I have to say is I'm very grateful to be here with you. I won't take most of your time. And I would like to say that tax law, people have to be attentive because since August, the virtual sections of the Supreme Court will have 4 or 5 repercussions about tax law. We've been with so many cases over the last 1 month and a half. So the issues that we are discussing are discussed undecided, no doubt. And the tax people saying that they're working very, very hard, very attentive. So thank you, and I'm at your service. So thank you very much, my friends. Miss Minister Alexandre, now our President Ricardo Marins. Thank you, Professor Fernando. I would like to thank for your presence, ministers, and for your talk. I would like to point out something about your talk. In an international forum, one of the biggest difficulties we have is the idiom that the person uses. I'm not mentioning Portuguese or English or French. I'm saying the what we have in mind variables from country to legal system. And you've presented a talk and raised several points, our participants outside Brazil. So some difficulties that are inherent with the internalization of the international treaties. It was very interesting for us, Brazilians, mainly the jurists that are here dedicated to tax law, but the participants of other countries also that had a glimpse with your talk of the big difficulties that we have concerning what to do with a convention, with a treaty that is signed by Brazil. It's an honor for our institute to have you, and we would like to have you with us in another opportunity in the noble room. Okay, inshallah. And I thank you all, Fernando, for being the share of this last round. I thank you all the 3 long days in openness, and I would say that we had 800 people, and the average was 250, 300 persons following each panel. So we'd like you to know that people have other affairs, but we have people from Brazil and abroad watching and taking part in this Congress. So virtually it was an advantage. So we had 87 panelists, which is a very expressive number. And 16 countries and several states of our Brazil. So it also gave the Congress a vastness, several divisions taking part, views of many people abroad and here. We have scholars, professors, attorneys at law, magistrates, representatives of the excise of Brazil and other countries. So people free to present their ideas in their point of point of view, the way people see the issues that were placed for debate. I don't have to repeat, the program was very well elaborated. I thank especially the Professor Eduardo Chueiro, Luiz Flávio Neto, and Rodrigo Maito da Silveira, that were, let's say, the heads of this organization. And I think that we're very successful. It could be better. Now, of course, nothing is perfect. Of course, we can always improve, but I believe that the panels here, I would say that most of them, the performance was so interesting for everybody that subscribed and are watching us. So I also have to thank people that we do not see. For instance, Teodoro, that has helped us a lot, Michelle, Eric,
and technical team, Luis at the library, Alicia at the secretariat. Others I could be endless quoting names and infinitely. I would like to thank all. And also, I would like to thank our sponsors. Without them, we would not have sufficient resources to do this event. And also, I would like to thank our collaborators, our supporters, better saying scientific collaborators, entities that without them, we at IBDT have a constant contact, AFIPECAV, and he's listing these entities that have an agreement with IBDT for research and development, Abradici says, Tax Academy, and sponsors that I want: Price, Waterhouse, Coopers, Bucharest, Machado Meyer, Pinheiro Neto, Lefosse. And the last point that Professor Shueri advised me and recalled me to mention here, we are on the eve of the anniversary of founder Rui Barbosa Nogueira. Tomorrow, Professor Rui Barbosa would celebrate 101 years. It would be his birthday. So those at the Institute, the love he had for the Institute, for the law university, it was his home. So he had three homes: the university, IBDT, and his own home. And also, and I think with Professor Barbosa was alive in spite of the advanced age, he would be so happy to what we conquered during these 3 days. I'm not judging on our own shoulders, but the what I'm saying is what is arising from so many attendees from Brazil and abroad. So I wrap up this Congress, recalling that in 2 years we will have one more international Congress, and we hope that it will be even better than this one, and always alternating. Next year it would be IBDT, it would be Brazil tax law, a strictly domestic Congress. So I invite you all to attend the next events of the Institute and follow through our website everything we have been doing during these last years, and especially during the pandemic period. Fernando Scaff, dear friend, thank you very much for your attendance. Again, Minister Professor Alexandre, thank you very much for your attendance, and good evening for all. Thank you. Thank you.